taking a look at what has been happening at the Court of Appeal. Well, maybe we should say at the courts in general. In recent times, we have seen some controversy emanating from the judgments as given by their lordships from the Courts of Appeal. Before now, there had been complaints about inconsistencies. I guess to stem this, the president of the Court of Appeal had said that there were only going to be two jurisdictions in which judgments would be given. One from the Lagos Court of Appeal and the other from the Abuja Court of Appeal. But has that really worked? Because it does appear that the term inconsistency was taken to another level only recently in the judgment given in the involving the governor of Kano State when the matter was tabled before their lordships. It does appear that in their closing statements there were some inconsistencies. One given favor given judgment in favor of the current governor. A second sentence dismissing the entire appeal for lack of merit, and then the third sentence in the same judgment given an award against the people who were supposed to be responding to that particular judgment. And people have said that is a level that they haven't seen. The registrar of the Court of Appeal has said, look, this is a typographical error which will be corrected, that the judgment, the oral judgment as given by the justices, remains valid, as the case might be. But there are those who believe that something must have gone wrong. And this is not without basis. And this is coming from the ICPC, some of the figures that we have right now. Because in Nigeria, it is no news that corruption is rife. There have been allegations of corruption even leveled against members of the judiciary. It shouldn't be heard. It shouldn't be the kind of thing that we're proud of, but it does exist. And there have been allegations coming from the parties affected that perhaps something was wrong in this particular matter. But let's just take a look at the general indices, which source, if any source should know about this, the ICPC, the Independent Corrupt Practices Commission, would know a thing about this. In their last corruption index, which was released in 2020, they spoke about lawyers being the most responsible for offering bribes for favorable judgment. They say litigants followed with 21.96%, court staff, clerks, registrars, etc., 21.54%, judges 16.88%, and government MDAs 7.37%. So it does even appear that judges come higher than even civil servants, which is something that should trouble us. The source is the ICPC. And taking a look at that, it also indicated that cases of outright demand and offer of bribes are mostly linked to election matters. They also allege that the total amount of money reported by the justice sector respondents as corruptly demanded, offered, and paid between 2018 and 2020 was 9.457 billion naira. I mean, I am very curious as to how the ICPC, got these figures and whether they were able to trace the actual, those figures. And if they were able to trace them, you would imagine that shouldn't they have been able to prosecute the people in whose accounts these amounts of monies were found, assuming, this were figures that were traceable. But these figures, as I quoted them, are from the ICPC, and these, general figures. I'm not seeing anything has gone down here. But if we know that this is our sector, this is the judiciary sector, and it is not immune from the general malaise, could anything, all of the allegations that we're seeing around these cases, there's multiple, or shall I say, conflicting judgments, some of them conflicting even in the judgments that have been delivered. Should we just dismiss them with a stroke of the brush and say, oh, well, mistakes happen and leave it at that? Would that be the right thing to do? Well, joining us to discuss this matter this morning are two gentlemen. Mr. Monday Ubani is a former chairman, section of Public Interest and Development, Speedle MBA. He's right here in our Abuja studios. You're welcome to Sunrise Daily.
Marco, thank you very much for having me.
And we also have Mr. Mason Nejo, who's a human rights activist and also a legal practitioner. He joins us via Zoom from Akure. Good morning and welcome to you, Mr. Nejo. Okay, I understand he'll join us shortly. I did see him a moment earlier, but I guess very, very soon we'll hear his voice at the minimum. But Mr. Ubani, this is the situation that we found ourselves. We saw this controversy, especially with regards to Kano, brewing this week. Initially, it was the, shall I say, triumphant entry of the governor back to Kano, even though it does appear that the oral verdict given was not exactly in his favor. But upon a closer inspection of the certified true copy of that judgment, it did appear that the judgment favored him. And then we heard that the registrar said, look, this was just a typographical error. The oral judgment still stands. That matter is going to go to the Supreme Court now from the look of things. But so far, so good. As a lawyer, I believe that you've been scandalized by all that has been happening so far.
Well, what happened with regards to Kano is something that I think should have been avoided. You remember that there was this conference we held in Lagos, section of public interest, and it was the issue of judiciary in the eye of the storm. We know that as we have concluded the electoral process, in terms of announcing the winners, that those who feel aggrieved, the law allows them to approach the court, that the court will be under serious pressure. The stakes are high. The political cases in Nigeria, and I know, is something else. Even the election itself is like a warfare. So every eye, on the judiciary, and those pressures sometimes can result into some of the things we are witnessing presently. Now, in the issue of Kano, the court has clearly come out to say it was a slip, maybe clerical error. That's what they said it is, but people are giving a different, all manner of interpretation. But the court itself has owned up and said, oh, we made a mistake. Clearly an error. The oral statement we made or pronouncement that we made, we still stand by it. But when these things are being typed, due to so many administrative pressures, either from the volume of work or from other issues they have to handle, a mistake can occur. And that's why even in our jurisprudence, we anticipate such thing, and it's called slip-through, clerical error. You can, while writing judgment, and say this particular matter lacks merit, you probably put do not lack merit. Or so either when it's being typed or when you are writing it as a result of pressure of work, you can make a mistake. Now, a judge is allowed to correct that even without putting parties on notice, because it's something that has no harm to the other parties. Is allowed. So if they now come up to say that it's an error, I believe because of this further appeal to the Supreme Court, that if there is any doubt whatsoever, or any crisis or any problem, that particular matter will be cleared at the Supreme Court level. That is my belief. So we don't need to kill ourselves over this, especially when they have come up to own up, oh, we made a mistake. To me, that should suffice for now until we see what the Supreme Court will say with regards to that.
Well, some people, some of your colleagues have also said there are different types of mistakes. They're, as you alluded, they're clerical errors. I think it was Mr. Chidi Odinkalu who was saying that, well, someone can intend to write Wi-Fi and write wife, or wants to write wife and write Wi-Fi, as the case might be. Those kinds of mistakes have been anticipated. But when you have entire sentences contradicting themselves, one given judgment in favor of a first appellant, the next saying, I find no merit in this particular matter, the third saying, giving fining, as it were, those who had brought the matter to court as it, Yeah, against whom the matter had been brought to court. I think the first respondents were fined, so to speak. These are heavy matters. This is not just something that one will make a mistake. It has to be an entire mistake of judgment, not a clerical error.
Yeah, in advanced societies, what they do that if things like this occur, they will carry out a very comprehensive investigation. And why they're doing that is to avoid a reputation, to avoid future, mistake of such being made. But here, most times we don't do things like that. We like to sweep things under the carpet. My thinking is that in the light of what the Court of Appeal has said that is an error, there can be an investigation. What could have happened? Was it intentional? Is there anything behind it? Could it be any inducement whatsoever? So in doing that, all the facts, will be assembled in order to get, to the root of the matter, So I think what we're doing at this point is is conjecture. We are all assuming, thinking. But the proper thing is, can there be an investigation? What has happened?
Yeah, but as a lawyer of many years at that, has this come as a surprise to you? I mean, how often does this kind of mistake happen?
It does, because we are still human beings.
How often?
Not too often. As I said earlier, the sleep rule, may not be as elaborate as, reaching so much inconsistencies in one particular judgment. You are saying this thing, this is the fact. All of a sudden, you are changing the story in between. And then finally, their conclusion is also inconsistent with the second message you have passed to the public. So I don't know whether it could be pressure of work. It could be the volume of work these people are doing. It could be the clerk that must have done this. When you finish writing this judgment, you give to them to type. They are also being induced. They can be pressured to do certain things and all that. So it may not be the judge that must have done it. It must be probably from the clerk. So it is important that investigation can be carried out. And at the end, you find out that you will lay the blame at a specific person who may have committed it. But whatever we're doing now is conjecture. We're all thinking.
Do you think that it is in order, though, that an investigation be carried out?
Yeah, that's the best way to do things like this. I'm worried myself. I'm a member of the legal profession. And then this kind of a thing is happening. And the members of the public are looking at what's going on. You made a pronouncement, and when it is now being written, certified through copy, showing a different thing entirely. So what do you do? For us, to have a sane society, the best thing to do is let's find out what has happened, who is culpable, and then there must be some level of punishment for those who are culpable. That's the way things are being in the civilized climate. That's my thinking. But things here, we can, let's forget it and let's move on.
Yeah, Moving on. Shouldn't we demand it? I mean, assuming that that's the idea, assuming the attitude of the judiciary on this one is just to say, it was a mistake, that really meant nothing, just much ado about nothing. Don't you think that it behoves on us to demand that accountability, takes place on this particular matter?
No, you see, we don't even need to demand it. It is about quality of leadership. If I'm in charge of a particular arm of our agency, and a thing like this occurs, I will be scandalized. I will want a situation where I find solution to it. Unless I'm culpable, I want to find out what happened. I'm the head, and this a kind of a thing like this has happened, and the whole world, is saying that this is absolutely, a bit, confusing. Why wouldn't I want to know what is the cause? Why do I need to be pressured in order to carry out an investigation? I will do it without any pressure. Look, what happened?
The head in this case is who?
Yeah, the head is the president of the Court of Appeal.
Okay.
Because the woman meant well in making sure that we have two divisions, to handle these cases, to avoid things like this. Remember, you said it in your opening remark.
Indeed.
She did that in order to avoid conflicting judgment and create some level of sanity. Now, in the process of doing that, you have discovered such a scandalous thing that has happened. Now, what do? You want to find out so that you can further, carry out reforms, even within the judicial cycle. That's my thinking,
So the president of the Court of Appeal now has a major challenge on her hands. But let's take a look at some of the wider, inconsistencies that had happened before now. Because usually when people refer to inconsistencies, they do not talk about it in the same judgment. It's just that this kind of one has been pretty peculiar.
Yeah.
What they talk about is the fact that on the one hand, it does appear that an appeal court on a particular matter had ruled in favor of something, and then it does appear that in a similar case brought before the same court of appeal,
yes,
another thing is said on the same matter or something that looks very, very similar. And I think one of the cases that we've seen in recent times is that of the Plateau State governor, and the judgment has sacked members of the National Assembly belonging to the PDP.
Yes.
And then people have said, look, this matter, we thought the Supreme Court had settled this, that this is a matter that concerns internal workings of political parties. I do not know what you have made, if you've had the time to look at some of the judgments, because some of your colleagues disagree. They say, H1 is peculiar in its own situation, and it doesn't appear that there have been inconsistencies. But some people maintain that these matters remain consistent, or let's say the underlying principles for these matters have been consistent, but the judgments haven't been. What are your thoughts on these inconsistencies?
Yeah, Mark, I will do some explanation, and it will be very simple so you will understand me. We're having issues with the issue of qualification. Unfortunately, qualification is both pre- and post-election issue. And so what we're having now is that in most instances, there is confusion at the Court of Appeal level as to where we should bring in this issue of qualification. Is it at the pre or at the post? And what are the facts that should support it? So I discovered that inconsistency arising from this issue of qualification. Now, if you look at Section 134 of the Electoral Act, one of the reasons to nullify an election is on issue of qualification. It is also an issue at the pre-election stage, when you are nominating a candidate, if he's not qualified. So what happens is that the pre-election issue, when it concerns issue of qualification, it must be a member of the political party who must have contested the election alongside with the declared winner that can now challenge that nomination and qualification of that candidate. And you must do that within 14 days, after which you cannot bring the issue at the tribunal. Statute bad. Now, if you come to tribunal when election has been conducted, and the opponent, the petitioner now is not challenging the issue of qualification, it must be very specific as to what qualification is under the Constitution. That it must be sponsored by a political party, that is the law, and that political party must be so-called a political party that has fulfilled all the requirements in order to present you at the general election. So what we're having a problem now is that most times there is confusion as to what are the facts that can lead to issue of agreeing on issue of qualification, whether at the pre or post. That is where we're having a problem. In a Plateau matter, if you remember that according to them, there was a judgment of the court when they wanted to conduct the primary, saying that this particular body or ESCO is not the proper ESCO to conduct the primaries. And I understand, even though other people are saying that is not true of what happened, that particular judgment was not responded, was not obeyed. They went ahead to conduct the primary, producing a candidate now that has what you call in African parlance, K-leg. So these persons now, the opponent now, is now using it and say, look, if you are supposed to be sponsored by a political party, was the political party in compliance with all the things that are supposed to be done in order to produce you as a candidate? So the issue now, will that matter be a pre-election issue or post? The Supreme Court will make final judgment on that. Are you following me? Because most times we are confused, at the Court of Appeal level, at times when there are these conflicting on this issue of qualification. But my own happiness and joy is that the Supreme Court has always maintained one precedent on issue of qualification. If it is a pre, then you have no right to bring it at tribunal. If it is a post, you have a right to, but they have the facts for it to apply. So I think that this will be cleared finally at the Supreme Court level. That's my understanding.
Well, we'll certainly wait for the verdict of the Supreme Court on that particular matter. There are many more questions which Mr. Obane will weigh in on when we come back from this break. Mr. Monday Obani, former chairman section of Public Interest and Development, Speedle of the NBA, is still here with us in our Abuja studios, and we've been taking a look at some of the matters that have been emanating from the Court of Appeal that seem inconsistent, and he's been weighing in on that. You have said that the Supreme Court will eventually, set the tone and ensure that all the confusion around these matters are straightened. But then we cannot dismiss all of the insinuations around corruption against the judiciary. It is sad. It is unpalatable. Sometimes, I don't want to say unfair, because some people will say people are innocent until they're proven guilty, until there is proof of guilt. But when you see figures like this emanating from the ICPC, something at the corruption index, you cannot dismiss them. You cannot exactly say this is not possible within the judiciary. How do we then, shall I say, take a second look to ensure that the judiciary is above board and that it is not the influence of filthy lucre that is driving some of these things that we are seeing in the judiciary?
In saying what I want to say, I'm not acceding to the facts alluded to by ICPC with the figures. You mentioned it. You also raised out, if you have knowledge of this amount of whose amount of money.
No, I didn't raise that. I raised questions.
You raised questions. Why were they not being prosecuted and all that? What method of research did they even use in getting these figures and all that? So I doubt those figures. But is there corruption in the judiciary? There is corruption everywhere in Nigeria, even within your profession and all that. So the most important thing is, let's address these issues holistically. Let's not look at it from only one side. My prescription always concerning our judiciary is that we must take care of the judicial sector in terms of proper financing, in proper taking care of the judges themselves by giving them quality welfare. When they are taken care of in terms of salary allowances that they deserve, and then put structures in place that give them room to operate efficiently, then you can now also judge them when they err. If you don't address those issues and you now come to attack, the problems that crop up as a result of foundational issues, you wouldn't have solved the problem. So my own holistic, prescription is, can we look at judiciary, completely and solve the problem? There is no other institution in the world as powerful, as revered as the judicial sector. This is only particular sector that plays the role of God in the society. They make pronouncement, and that pronouncement stands. You can come today as a free person and you are going to correctional center as a result of a pronouncement of a judge. God so much believes in judges, and that responsibility has been amplified by the society in asking them to do this backed by law. No other institution, not even the reverend, not even the imams have the power of judges. So in such responsibility, we must give them all that is requisite for them to succeed. Infrastructures, on the condition under which most of them operate. Most of them, in fact, I was in court one day, I told you, in Court of Appeal, one of the judge presiding said, Mr. Bani, two judges are in the morgue. They are in the mortuary. As a result of pressure of work, we're overworked. Even these electoral cases we are talking about. Do you know how many cases these people are handling? Sometimes they cry. They want to, let out their distance and say, we are being overburdened. No, judges are not being appointed to reflect the number of cases that are in the courts. Yet they're expected to perform excellently well without any. There are problems. So let's solve the problem of judiciary. I'm very happy recently there was this all judges conference in Abuja, where the president and the Senate president made promises of really taking care of the welfare of justice and then ensure that all the things that they require to succeed efficiently in the system will be made available to them. So it is when you do all that you can now place them on the scale and say, look, we have done this for you, we have done this, we have provided everything, so you have no reason to fail. So my take is that I'm not making excuses for them. I'm not saying there is no corruption in the judicial sector. But we must also address the fundamental issues of taking care of the judiciary and making sure that they work under a very conducive atmosphere. So we cannot judge them, properly when these things have been done and they are not doing well. And then in the recruitment process, we have also said there are issues with it. There are those who are there who are not supposed to be there, and you cannot bring rotten eggs and put in the system and expect, this expectation will be very wrong. So we are saying let's also address that squarely, even in the recruitment process, and then give them all that is required to make them work, and then now place them, on a scale and judge them appropriately. So I'm saying there are issues, but we must get to the root of the matter and address them squarely.
So you're saying that until we address those issues, until we, pay judges well, we shouldn't probe, we cannot probe corruption?
It's an intelligent question. I cannot say that. I'm saying in addressing the issue of corruption, in addressing all the factors that causes deficiency in the system, let's also include the factor that I've just mentioned. I'm not making excuses. Where there are issues of corruption, we have seen where agencies have acted, and some of them have been punished. We have known that here in this country, where they have been taken care of. But in doing that, let's also address this issue in addition. That is what I'm saying. I'm not making excuses. I'm not exculpating them. I'm not saying we shouldn't even investigate whether. And that's why I said investigation should be carried out on this one that just happened. I'm saying that, but let's address this issue in a holistic manner. That has been my prescription.
Okay, let's go to Lagos now. Ayo.
Thank you, Markwe. I understand that Mr. Nejo is also with us this morning. He's a human rights activist. You introduced him earlier. If you're there, Mr. Nejo, can you hear me?
Hello?
Yes. Okay. Can you hear me, Mr. Nejo?
Hello, can you hear me?
We can hear you. Can you hear me?
Okay, good morning.
Good morning. Can you hear me?
Yes, I can hear you.
Okay. Well, I just wanted to, I don't know how much of what Mr. Obani said you have listened to, but the troubling fact that after the ballots have counted, then in the courts, court decisions overturn some of the decisions of the people, so to speak. That's one of the troubling things. For instance, as at September this year, 7 senators and 23 members of the House of Representatives have been removed from office by the courts. And of course, you are not unaware of the latest issues of governors being removed by the courts and all of those things. How does that come across to you, that after the ballots, the people's votes have counted, the judiciary is overturning them?
It is a sad, very sad situation. When you look at what is going on in the judiciary, like I said, it's a sad one. There's nothing like precedent again in our law. When I was in law school, I was taught that precedent, it is the judgment of the higher court. The judgment of the higher court by the lower court. But today, in the judiciary, what we see is a different entirely. When you look at what is happening here and there, like the issue of Kano, issue of Plateau State, issue of Nasarawa State, conflict judgment everywhere. What happened to this issue of precedent? And Supreme Court is the final court is the final court. But today, Supreme Court will tell you, oh, don't eat yam in the afternoon. They will come and tell you that you can eat little. Just eat little. It's a sad moment for lawyers in this country.
But what do you think is responsible for such activity, Mr. Nejo?
Corruption. Corruption is everywhere. Let me tell you a story. A client came to me and said he needed my service, and I said, okay, this is what I'm going to take. And he told me that, don't worry, what I just want you for is just for you to go to court. I've discussed with this chief judge. I don't want to mention the chief judge now. I've discussed they're going to put the case in the one court. It's for me to just shoot. That's all. What I'm charging is all that I should reduce my money that he has already settled. You see this kind of embarrassment? when the clients will come to you and be saying that kind of thing to you, that I've seen the judge, you just collect your own for you to just show in the court. This is what we are facing, my brother. I had my medicine where I was talking about remuneration about it. If you would like to pay them 50 billion, those who want to collect money will still go ahead and collect money. It's not all of them. Yeah. They are good judges, but there are some that if you just mention their name to any of the politicians in this country, they will tell you, oh, what do you want? Is he an expert or that you want? Will not also judge. You whatever. So it's not the. I don't believe it's the money. It's about integrity. And we not see what is happening in other countries.
So, Mr. Nejo,
but here in Nigeria, why is it that this place, our own situation is different?
Okay. One of the things that Mr. Ubani said, and I hope you heard that as well, which of course we might want to take him up on, is that it is because the system has made it such that it is easy, so to speak, to compromise the system. For instance, in the case of the documents that are said to have typographical errors, that he said that anyone could be induced in the court system, in the judiciary system. What do you make of that, and how do you think we can insulate the judiciary from these manipulations?
Well, our law is very straightforward. When you look at this, all these judgments, you are asking somebody to come and prove. When you look at section 137 of the Electoral Act, it says it shall not be necessary for any party who allege no compliance with the provision of the Act for the conduct of election to call oral evidence if original or certified true copies manifestly disclose the non-compliance alleged. Today, Court of Appeal has killed this session, calling parties to come and be proven. And the session is very clear. This session is very clear. But today, all these judgments do not reflect what is in the session.
All right, Mr. Nejo, well, clearly this conversation is an endless one, and we'll continue to push the barriers until we get to where we're going. Thank you so much for your time this morning. Mr. Nejo is a human rights advocate and legal practitioner who joined us from Akure in Ondo State.
Thank you.
Yeah, it's back to you, Markwe.
Oh, thank you very much, Ayo. Your closing comments as well. Just want to quickly get your own reaction as to how we should proceed while we wait for the Supreme Court, and we believe that they will straighten this out.
Yes.
Do you also believe that the President of the Court of Appeal should there be a review of the judgment, some of the judgments that have been alleged to have conflicting outcomes given, even the same basis?
The problem with National Assembly matters is that it ends at the Court of Appeal. With the lesson of insight, one probably begin to see the reason why the governor's matter ends up at the Supreme Court. It used to end at the Court of Appeal. It is things like this issue of conflicting judgment that made those policymakers to say, please, let it not end at the Court of Appeal. Let's come to Supreme Court. Supreme Court, most times, strengthened our law, especially in electoral matters. Where we're having issues, electoral issues. We don't have issue with contract, with consumer matters, and all, but when it comes to election issues, it is the stakes that are so high that have now put pressure on the system. So what we'd rather do, which we have always been recommending, let's try as much as possible to get it right at the polling unit. Our electoral system must have credibility at the polling unit. If it does that, look at what happened in Liberia. The loser will congratulate the winner immediately. Because when everyone sees that the system is fair, that everyone is allowed to participate in the process and elect who will rule them, then the loser will say, what am I going to court to do? Because the evidences are overwhelming. It happened in Liberia just 3 or 4 days ago. So it is getting it right that we now put less pressure on the judiciary. We are putting so much pressure on the judiciary. And they are human beings. They are not God. They are not God. They are human beings, for God's sake. So these things are what, and let me tell you, the clerks, those that work with them, most time they can easily, because they, what is the level of training? I have had a situation where a court has ended a matter. Somebody went and brought a survey plan and inserted in a matter that was never part of the proceeding at the lower court.
Well, Mr. Obani, I'm sure we can go on and on. Certainly enough to talk about. We have to thank you so much for your thoughts with us this morning. Monday Obani is the former chairman, section of Public Interest and Development, Speedo of the NBA. Oh, we'll take a break at this moment and we're back to discuss electoral reforms. What should be done? In just a moment, please stay with us.